Anytime you're overseas and you stop somebody, they say to you, "What's with these Americans? How come they think their laws can affect foreign citizens and foreign places? And why is their jurisdictional arm so long?" We're here today to answer that question. My name is Alex Spiro, and I'm a partner at Quinn Emanuel Urquhart & Sullivan. Most U.S. crimes and the way we think of U.S. criminal law has to do with territoriality, meaning it happens in the United States. There is a presumption in the law against extraterritoriality. What that presumption basically says is, unless Congress specifically says that this law takes place and precedence and has lawful power abroad, it doesn't. So in the United States, you can't use hard drugs, cocaine, things like this. You can use them in other countries in Europe. The question is, can a U.S. law prevent you from doing that? And the answer is not unless Congress writes in the law that any U.S. citizen, even when they're abroad, can't use narcotics. So one example of when U.S. law applies abroad is if you're a U.S. citizen abroad. The U.S. regularly regulates the conduct of its citizens even when they're overseas. An example would be if you're in China on vacation and you commit the crime of insider trading, you can still be prosecuted in the United States. It doesn't matter that you're overseas. The other example is when you're not a citizen, but your conduct is against a citizen. Let's say you're a foreign national and you make false statements to an American citizen to procure an investment. You are committing securities fraud against that individual and you can be prosecuted even though you're not a United States citizen. You might be in a foreign country and saying to yourself, "I'm in a foreign country, I'm a foreign citizen." But if you're interfacing with a U.S. citizen, even if that U.S. citizen is abroad, Congress can regulate that conduct. We had the example in which a U.S. citizen commits a crime. We have another example in which a U.S. citizen is the victim of a crime. But there's a third category in which the United States itself is harmed. What you typically see, and the hook that the United States can use to bring a lot of foreign conduct under their orbit, is the banking laws and the chain of commerce. Let me give you a couple examples. We see this in the Swiss banking cases, where even though we have Swiss nationals obeying Swiss law and dealing with bank secrecy laws in Switzerland, the United States says, your conduct touches our banking and our regulatory system and we can prosecute you. Another example is the FCPA and bribery statutes. While the conduct might even be acceptable in that foreign territory, it's not under US law. And so while it might seem small or unimportant, it can have major repercussions for a business or a company and can actually land executives in prison. There's one more category of laws that so deals with conduct that so shocks the conscience that we say that there is just harm to everybody. And so by harming everybody, you're also harming the United States. These are things like war crimes. We don't prosecute people who have bar fights in Dublin, but you could have this strange example where a foreign citizen is in a foreign land bothering foreign people, and the United States still takes jurisdiction. If you engage in complicated financial transactions, things involving taxation, or any bribery abroad, U.S. citizen or not, you can rest assured that the United States government believes that they could have jurisdiction over you. Thanks for watching Talks on Law. My name is Alex Spiro.